Good evening to everybody. Welcome to the today class of this burden of proof for the JCJ 2022 main examination. Anyone can unmute and read what I posted on the screen. Hurry up.
Welcome to the aspirants of JCJ 2022 main examination, Indian Evidence Act, Burden of Proof, Professor Dr. Mohammed Saheb Hussain, Professor of Law School, School of Law, St. Augustine University of. Sir, please can you
You
share
read
the screen
several
totally?
times and you know several times. Read now. Down.
School of
Down.
Law, Fort Mwanza, Tanzania, East Africa. Tanzania,
Yes.
East Africa.
By looking at even the shortcuts of also you can able to read it because your mindset is in a set in a such a way. St. Augustine University of there is a words are there only upper would be seen Tanzania and the words are there Mwanza and the words are there Tanzania East Africa. Could you make it out? Unless until that you know that full, then only you can make it out. Okay, without wasting the time, let me come to the point of our study and the provisions of the burden of proof under Indian Evidence Act, how it would be there. Today, I requested in the WhatsApp group, please make the calendar. Please make the calendar. And according to that, everybody know that what I am going to do next day, so that you could read and come to the class, and the class would be the participatory class. But everybody said only one has Sandhya has responded, but she said okay sir, okay sir. But till now I did not receive from her. Okay, doesn't matter it. Introduction, and at least tomorrow that calendar would be there. You know that what I am going to teach tomorrow. At that time, at least you read it what I and come to the class in the participatory class. That is the best way to learn the things. Otherwise, if you just come without reading it, and it will like teaching to the wall. Unless until I will pressurize you. Yes, read what is the introduction. Anyone can unmute and read. Anyone can unmute and
Introduction.
read.
Yes, sir. The term introduction. The term burden of proof means when a person states something and considers it to be fact, he or she needs to prove the statement made by him. This is an important concept integrated in the Indian Evidence Act 1872. The concept of burden of proof is explained in Chapter 8 of Indian Evidence Act 1872.
Yes. The term a single inverted comma begins, burden of proof it ends means when a person states something. Any person states something and consider it to be the fact, and it is a fact, or he or she needs to prove the statement made by him. That means a person who makes the statement should have to prove it, and the burden lies on him or her. This is an important concept which is integrated in the Indian Evidence Act. It is kept in the Indian Evidence Act, and the concept of burden of proof is explained in the chapter 7 of the Indian Evidence Act 1872. And the LCQ, in the MCQ meta burden of proof is given the which chapter? Answer is chapter 7. Can anyone say that burden of proof in which section it is given? Because multiple choice question you did it. From which section to which section burden of proof is given? At least starting section you can tell me. If you don't know, you say pass on. Don't waste the time.
101, sir.
It is 101, you are right. So, section 101 of the Indian Evidence Act says, of course, I quote, whoever desires any court to give a judgment as to any legal right or liability dependent on the existence of the facts which he asserts must prove that those facts exist. Means a person who says the fact, he should prove that that fact exists. When a person is bound to prove the existence of any fact, it is said that the burden of proof lies on that person. If a person says any fact, it is he or she supposed to prove it. Is it clear?
Yes, sir.
Is it clear? Say yes.
Yes, sir.
Can you repeat
Yes, sir.
in your own words? Say yes, sir. What? You repeat.
Yes, sir.
What yes, sir? I say repeat. Not yes, sir should repeat. Burden of proof should be repeated. A person who makes a statement, a burden lies on him or her to prove the facts are exist. Repeat.
A person, when he makes a statement, he has to prove the facts which he has made.
Yes, that is only the thing. You can write in your own words. Need not to reproduce the 101 section. Instead of reproducing it, if you write in your own words, it doesn't lead to the plagiarism. Is it clear?
Yes, sir.
Read the thing, write in your own words, enough. Need not to reproduce the same word. Okay, this section states that if someone is desirous of obtaining a judgment or any order from the court or authorities upon some fact which he thinks are true and correct, that he is required to prove the same. Why you go to the court? Tell me.
For seeking any relief.
You want to get
problem
some
is there.
relief. You want to see that the court will give some judgment. You want to see that the court will give certain decree based on the facts that you are going to prove it. So, the facts which the things are true and correct, that he required to prove the same. When he say that is a true, genuine, correct, then you have to prove it. Whoever is required to prove the said fact, it is said that the burden of proof lies on that person. So if he wants to say, suppose if you want to prove that you are alive, how do you prove it?
Birth certificate.
You go to the doctor and say, sir, give me the certificate that I am alive. And he will check it and he will give the certificate. Then you go to that office where you want to submit the, sir, I am alive. Then you are, who are you? Then you said, I am so and so. Where is your identity? And this is my identity. Where is your certificate? This is my certificate. Whenever the pensioner would get the pension, each year he has to produce the life certificate. Is it clear?
Yes, sir.
The following examples will help for the understanding these concepts better. Read the first one, first bullet.
If Ram is of the opinion that Shyam has committed a crime and that he must be punished for the same, then it is upon him to prove that Shyam has committed the said crime.
In the thappad, I have shown you. How could you prove that he made a thappad? No one is there, only wife and husband. Tell me. No one is there, only wife and husband. Give me the answer.
He might have taken some video.
Nothing is there. Say pass on.
Pass on, sir.
If the thappad is given on the slab in a such a way, the hand fingerprints are over there on the slab, on the cheek, she will go to the doctor and take the fingerprints, the snap. And that will be the proof. If she wants to prove. But it is she wants to prove it that her husband have slapped her. Is it or not?
Yes, sir.
Suppose if she recorded, okay, that is a corroborative evidence. And in the recorded sound is there. And if it is a vision also there, the vision also be there. So, if Ram is of the opinion that Shyam has committed a crime and that he must prove he must be punished for the same, then it is upon him, means Ram, to prove that the Shyam has committed that said crime. The second example bullet is, Rita is of the opinion that certain land belongs to her But Sita has occupied the same, stating it is her land. If Rita decides to file a suit and obtain a decree stating that the land belongs to her, then she is required to prove the same to the court. Hence, here the burden of proof is on Rita. Because she wants to claim that land becomes. Suppose if she wants to claim that land belongs to her, what she has to produce to the court?
Some documents relating to property.
The property title deed should be shown to the court. And the property always, I told you, it should be registered. Is it clear?
Yes, sir.
We already done the Stamp Duty Act and the Registration Act. Now let us see the 1 or 2 of the Indian Evidence Act. I quote, on whom burden of proof lies. The burden of proof in a suit or proceedings lies that a person who would fail if no evidence at all were given on their side. When you want to say that belongs to me, it is you have to prove it. If it is a civil case, if it is a criminal case, who has to prove it?
Prosecution, sir.
Prosecution should have to prove it based on evidences, either in the form of the direct evidence or hearsay evidence or the witnesses or any other document. Sir, in the criminal case, what is the document, sir? Tell me. If you know it, you tell me. If you don't know it, you say pass on. Don't waste the time.
Charge sheet and FIR or the documents, sir.
Only these 2 documents are enough.
Caesar Mahazarnama, recovery memo.
Even yes, expert opinion in the medical certificate.
Yes, sir. According to the case, it depends.
I say criminal case.
Yes, sir. In some cases, it required. In some cases, it will not be required, sir.
In the criminal cases, if he has stabbed him or her,
Yes, sir. In that case, doctor opinion is
doctor medical certificate should be there. Otherwise, case will not be even FIR. The charge sheet will not be filed. Even FIR cannot be filed without the doctor certificate. That will say MLC.
No, sir. FIR will be filed, sir, even without doctor certificate, based on the facts and information.
But based on cognizable and non-cognizable, how they will decide it?
Because facts are there, sir. He murdered means
merely facts are enough. Suppose an accident happened over there, merely facts are enough without the MLC.
For the first information report, facts are enough, sir. For proving a case, charge sheet is needed, sir.
But in which charge that he wants to make it out?
In trial, he has to make it out that
there must be necessity of the MLC. MLC cannot be given by the each and every hospital. Only recognized hospital, there is a condition would be there. Then only they will be given, and that to be the hospital will send the MLC to the respective jurisdiction police station. So the section state on whom does the burden of proof shall lie. In case a suit, burden of proof usually lies on the person who will suffer if the same is not proved. This means that it is necessary for a person to prove his case since he was the one who has filed a complaint or suit. Person filing such a complaint or suit will have to bear the loss of if he or she unable to convince the court with the facts that they are stating in an illustration. Okay, Sunil has filed a case stating that the land which is in a position of Anil belongs to him. I repeat, Sunil has filed a case stating that the land which is in possession of Anil, means who is the possessor now?
Anil, sir.
Anil is the possessor. And who is claiming?
Sunil is claiming.
Sunil is claiming. Here the burden of proof is lies on whom?
Sunil, sir.
It is a Sunil because he claims it. Hence, if Sunil does not prove it, the land belongs to him, then Anil will continue to have the possession of the land. Is it clear?
Yes,
Yes,
sir.
sir.
And Sunil will suffer by losing his land because he could not prove it. When he proved that the land belongs to him, he should show all the evidences to say that the land belongs to him. The best evidence is registration of the land. Is it clear?
Yes, sir.
What is Pahani?
Pahani is also a document showing the possession, sir, who is in possession of the land. It relates to agricultural land, sir.
Okay. But the registration of the house is concerned, the registrator will issue it. Is it not?
Yes, sir.
Okay. So let us see the 103 of the Indian Evidence Act. Burden of proof as to particular fact. The burden of proof as to any particular fact lies on that person who wishes the court to believe in its existence, unless it is provided by any law that proof of that fact shall lie on any particular person. Let us see that what exactly this section mainly talks about the burden of proof in relation to a particular incident or fact. If a person wishes that the court should believe the existence of a particular fact, it is upon him to prove that the same. In simple words, it means that if a person wishes the court to believe the story and that he or she has narrated, then she will require to prove the same to the court. Whatever that he say, whatever the story he say, whatever the facts he conveys, it should be proved by him or her to the court. For here, the example is Chirag says, Chirag is the name of a person. Chirag says that at the time of his neighbor's murder, he was not at home and he was at his uncle's place. In this case, it is upon Chirag to prove that he was at his uncle's place. What is alibi?
The example is alibi, sir, because at the time of crime, the accused is not at scene of offense and he was somewhere else, sir.
And in
If
many
he-
of the cases, generally they say, see sir, I was not here. I was undergoing the treatment in the so-and-so hospital. Or he is attending the marriage in the so-and-so day, so-and-so place. Because the video is there and everything is there. The same timings are there. When you hear the video recording, it will record the time also. Am I right?
Yes, sir.
So he say alibi that he is not present over there when the situation happened over there. But why it is come? Because they want to take the vengeance. That his name also be included to make him suffer. Are a criminal case against him so that he could not contest in the election. Are you following me?
Yes, sir.
Okay.
Yes, sir.
Section 104 of Indian Evidence says burden of proving what to be proved to make evidence admissible. So, the burden of proving of a fact necessarily to prove in order to enable any person to give the evidence on any fact that is on a person who wishes to give such an evidence. Like in an example here given is, Neeta states that Anita has made a dying declaration. Neeta states that Anita has made a dying declaration. Then who is going to die?
Anita, sir.
Anita is going to die. In order to prove that Anita has made a dying declaration, Neeta will have to prove that Anita is dead. And hence, the burden of proof of both the facts lies on the Neeta. A person who wants to claim any statement, that person should have to prove it. Sir, how could you prove that she is my wife? Anyone?
Marriage certificate, sir.
It is a marriage certificate is there. It is a marriage in a wedding card is there. And photos are there. Are the date and the public are evidences are there. Is it clear?
Yes, sir.
And moreover, there is a document is there. The passport, your wife name also there. In the passport, your father, mother name also there. Sir, where sir? At the last page. Did you see any time? Sir, we did not make the passport, sir. Why we did not make? Sir, we don't want to fly. If you make a small vision, and Abdul APJ Kalam says, because I presented a paper and there I wrote it. If you make the small vision, it is your crime. It is a crime. Are you following me?
Yes, sir.
Because I told you, I presented a paper in the international conference, and there I made this point very much clear. I will show you also the, because in the 18th I presented, and the research. Yes, this is final. I will tell you in the last that I quoted. In the first also I quoted. I quote, all of us don't have equal talent. I repeat, quotation, all of us don't have equal talent, but all of us have an equal opportunity to develop our talent. If you don't utilize the opportunity, and you are a loser. Dr. Abdul Kalam, APJ missile man. In my last, I also ended with this. With that, can you read the last statement? Is it visible?
Yes, sir.
Read.
The author begins his research paper with Dr. Kalam's quotation and ends his research paper again with the quotation of Dr. Abdul Kalam, APJ. As a young citizen of India, armed with technology and love for my nation, I realize a small aim is a crime.
If you realize a small aim is a crime, and I told on the day, I don't know whether you are live, you saw my, did you hear my speech when I was spoke?
Yes, sir.
Then I made one statement. My vision is there. My aim is there. I want to fly without my money. Not only me, my wife and children should have to fly on the money of somebody else. And I proved it. That is my vision. Whenever I see the plane, I used to have such a vision with me. So have a big vision. If you don't have a big aim, it is your crime. That's what I want to say. Is it clear?
Yes,
Please
sir.
make the passport. Did you make the, so make the passport, whether you fly or not, have the big vision, because you don't want to die in the same place where you born. At least visit the places where you want to see the other places also. So here, dying declaration, one should have to prove it. Then burden of proving of the case accused is, the next point is 105. The burden of proving the case of the accused comes within the exceptions. When a person is accused of any offense, the burden of proving the existence of circumstances bringing the case with any of the general exception to the Indian Penal Code. Of course, the Indian Penal Code gives the exceptions. Can you tell me what are the exceptions in the Indian Penal Code? From where it starts, where it ends?
76 to 106, sir.
I appreciate. Within any special exceptions or a proviso contained in any other part of the same code or any law defining the offense is upon him, and the court shall presume the absence of such circumstances. Suppose if you see the illustration, you could have the clear-cut idea about the section 105. Read the section illustration.
Mr. Sethi is accused of murdering Mr. Gulati. Mr.
Gausia,
Sethi
give the
pleads
chance to the Deepika. Deepika, you read it.
Mr. Sethi is accused of murdering Mr. Gulati. Mr. Shetty pleads that it was not murder but self-defense, as Mr. Gulati was about to shoot him with his gun. Then the burden of proof is upon Mr. Shetty to prove that upon grave and sudden provocation, Mr. Shetty, in his self-defense, killed Mr. Gulati.
Yes. What is the defense is taken here?
grave and sudden provocation, sir.
Grave. What is a remarkable case law on the grave and sudden provocation? It is a very remarkable landmark case law. And we discussed several times when I was teaching for the MCQ. On that case law, a movie also made, and where I have forgotten the actor name because I could not. When you don't utter the actor name, that you will forget it. Akshay Kumar. He is a commander. I give the hint. Still, you are not giving. Say Pasan.
Pasan, sir.
K.M. Nanavati versus State of Maharashtra. Is it Maharashtra, State of Bombay?
Maharashtra, sir.
Where a police officer, that is the commander, the second day he shot with his service revolver. And I also told you two words especially. In the Telugu, Mindadu. What do you say in English? Means a wife will have a BBC with another man. And the man is a married or unmarried, doesn't matter. Keeping the illicit relationship. Umpudu katte, Telugu. What do you say in English? If you don't know it, say pass on.
Sir.
Umpudu katte means concubine. Concubine. And that I told you Telugu in the Mindadu, it is a English word is paramour. Paramour. Is it clear?
Yes, sir.
So, this is the same thing. Mr. Shetty is accused of murdering Mr. Gulati. Mr. Shetty pleads that it was not a murder but a self-defense. He wants to kill Gulati. Was about to shoot him with his gun. Then the burden of proof is upon the Mr. Shetty to prove that upon grave and sudden provocation, Mr. Shetty in his self-defense killed Mr. Gulati. You might have seen the cowboy movies. Did you see the cowboy movies? Sir, we don't go to the movie because we don't have that much money. If I do have money also, we don't go to the English movie because we could not understand. And we'll see only the Telugu movies, Nagarjuna. Is it your answer? Say yes or no.
No, sir.
No, sir.
What is your answer?
We have not watched, sir.
In cowboys movies, there is a game. Okay, now ready. 1, 2, 3. Each were having their revolvers or guns. And each one should have to kill anybody in the self-defense. So now the question comes. If a person wants to kill you with the revolver, at the time you are also having a revolver or gun, you can shoot at him because in the self-defense. If you don't kill him, and he will kill you. But if a person wants to use the guler, what do you say English? A stone would be there, a V-shaped wood, then they tie the rubber and they keep the stone and they pull it. If you don't know, say Pasa.
Catapult.
Catapult, Catapult. If you use a catapult to strike you, can you take your revolver, shoot at him in the self-defense?
No, sir.
Answer no. Because proportionate force should be used over there. So, when he wants to say it's a self-defense, it is he has to prove it. Or, if he provoked, Gulati provoked him, they have to prove it. Then, when they prove it, is not amount to murder, but it is a culpable homicide will come. Okay, burden of proof in the case of civil cases. How the civil cases, when a person of the civil proceedings contains the two things with it. The first one is the fact that the case, and the second one is being the legal reason. The burden of proof in such a case is upon the person who files such a civil suit, known as the plaintiff. This means that if the plaintiff is unable to provide the evidence and proof and is not able to convince the court the facts are in existence or are true, then even if the defendant does not offer any defense or state anything, he will win the case. Suppose the defendant always take the defense. Am I right?
Yes, sir.
Good. The plaintiff should have to prove that, whatever the fact he stated. Therefore, in such a case, the defendant usually try to harm the plaintiff's case in some way or the other rather than the positively proving their side. So naturally, it is a person who goes to the court should have to prove it. So burden of proof in the civil cases goes like that. But the burden of proof in the criminal cases is the state. Is it clear?
Yes, sir.
In this case, the burden of proof shall then lie upon the accused to prove such exceptions or claim. It is necessary for the prosecution to prove that their case is beyond reasonable doubt, which means that the burden of proof upon the prosecution is quite heavy, and thus accused or the defendant gets a good advantage. What is the maxim where the beyond the reasonable doubt is based? If you don't know, you say pass.
If you give any clue, I may try to say, sir.
Let dash will be acquitted, but
Yes, sir.
dash cannot be convicted.
Let 1,000 accused may be acquitted. One innocent should not be punished, sir.
That is, in some, can you tell me who said that statement? In some places they say 9, and some places they say 100. In the MCQ, there is a question also, and we discussed this. That is why we say beyond the reasonable doubt. And hence, even the criminal cases, a person is acquitted. It doesn't bar for the civil case.
Yes, sir.
For instance, in the accident cases, beyond the reasonable doubt, he is acquitted. It doesn't mean that in the Motor Vehicle Act, when you file a case for the compensation, that acquittal will not be a bar. Am I right?
Yes, sir.
Good. MS Reddy versus State of Inspector of Police, ACB, Nellore case law it is. Preliminary burden of proof falls upon the prosecution. In the above case, it was held that the preliminary burden of proof falls upon the prosecution. It is unfair on the part of the defendant to be the one bearing the burden, and it is important for the prosecution to establish his case upon its own findings. It gives an undue advantage to the prosecution if the defendant places their evidence first, as this will only give a chance to the prosecution to poke holes and use the strategy to get through the things. That means whenever the burden would be there in the prosecution and the criminal cases are there, the prosecution should have to prove it. Till it will be proved over there and he will be treated as a
Innocent.
innocent. I appreciate. You cannot say, that's why you say accused. We don't say he is a guilty person. The guiltiness you have to prove it. Is it clear?
Yes, sir.
Savitri versus Kartyani Amma. Each party has to prove its allegations. In this particular case, there was a question of execution of a will and being executed by coercion. The court held that each party had to prove its allegation, which means one alleging that the will was executed by coercion has to prove the same. So if you want to see that the will is prepared in the coercion, you have to prove that, because the will was written at the zero range, keeping the revolver at Telugulo kanta antaru. What do you say in English? If you don't know, you say pass on.
Pass on, sir.
Why only Gausia saying other are sleeping?
Pass on, sir.
Yaksha.
Pass on, sir.
That means you did not hear my MCQ classes. Several times I dealt with this in the MCQ classes.
No, sir.
Yes, sir.
How many
Not
kantas
at all.
are there for you, man? Only 5 minutes are left. Enni untai kantalu?
What does Kanta mean, sir?
One, sir. One member.
It is the That Kanta, I will say you in because in 5 minutes are there. I will show you the. This Kanta, here it is shown. Could you see it now? This.
Okay.
Could you see it now?
Yes,
Yes,
sir.
sir.
Yes, sir.
Why you are keeping quiet?
Yes, sir.
I am a cursor rounding. Where he is put the hand? On the Kanta.
Face.
How many Kantas are there for a man?
2, sir.
దాన్ని ఇంగ్లీష్ లో ఏమనాలా? టెంపుల్. TEMPLE. Temple. Say the spelling.
Temple means Devalayam Gudi. It will come like.
నానార్థాలు.
Okay, sir.
See here it's saying. Did you see it is a forehead? Did you see?
Yes.
This is a
Yes, sir.
ear. And this is a temple. Here. The 2 temples are there for a man. Suppose if a person has kept a revolver at the temple and say, write the will. Do you write the will or not?
Yes, sir.
Why?
Because of fear of death, sir.
In Urdu, there is a saying is there. I don't know whether you remember it or not. Yes?
Which one, sir?
What is that statement?
I couldn't recollect, sir.
Jaan bachi to lakho paaye. Jaan means life. Bachito means if life is there. Then lakho means lakhs. Paaye means we can earn. If the life is there, we can earn lakhs. Is it clear?
Yes, sir.
So now
Yes,
at
sir.
least you know what is meant by temple.
Yes, sir.
What it means. 2 meanings are there, temple. See here in the photograph it is shown. The same spelling. TEMPLE. Is it shown or not?
Yes, sir.
Here cursor I am showing.
Yes, sir.
So temple in Nanardalu. Say in English.
Synonyms.
Synonyms, sir.
I appreciate. At least you told me. What are these opposite?
Antonyms.
I appreciate. Anyway, at any time it will be closed. Again, tomorrow I am going to deal in detail some of the cases so that you know that burden of proof lies on whom. And at any time it will be closed. And before it, I would like to say that tomorrow class also you are going to study the
Burden of proof.
on whom it will be applied, on whom it will not be applied, and who has to prove it, who has to disprove it, what is the position in the civil cases, what is the position in criminal cases. Again, we will pay some more interest. And tomorrow you are supposed to read and come to my class.
Okay,
What do
sir.
you want to read?
Okay, sir.
All the burden of proof with the cases also you have to read it. Then you come to the class. Then we'll make a participatory class. If you participate it, you will learn anything. Sir, if you don't participate also, we can watch your YouTube, sir. In watching that you are getting only 50 to even 40 to 50%. But when you participate, you will get 75 to 80%. You know how much I get it? I get 100%. Why?
Because you are teaching.
I read, I understand, then I digest, then I teach you. So,
Yes, sir.
who is the selfish person here?
You, sir.
See, I am teaching. Means